Good morning, everyone. It's nice to see you all on a Saturday morning. And to make the morning even better, we have two delightful guests, Ms. Ritvika Sharma and Mr. Kevin James with us, who are going to talk about their research paper titled as Fiscal Federalism and Centrally Sponsored Schemes, that is Rethinking Article 282 of the Constitution. Let me now start the session with their introductions. Let me first talk about Ms. Ritvika Sharma. Ms. Ritvika Sharma is currently a senior resident fellow at Vidhi and lead at Charka, that is Vidhi's Constitutional Law Center. Her research is basically focused on comparative federalism, local governments, and electoral reforms. She has also advised various departments of the Government of India when it comes to constitutional validity of the proposed legislations and legislative competency of the Union and the state. She has also assisted the Union of India in preparing its written submissions at the National Judicial Appointment Commission case, that is NJAC case. She has graduated from BA LLB Honours from Indraprastha University in 2013. In 2014, she did her LLM from Nalsar University of Law. She has also obtained her LLM from University of Cambridge in 2018. Let me now talk about our second guest, Mr. Kevin James. Mr. Kevin James is currently a research associate at Center for Social and Economic Progress. He's also an honorary fellow at the Center for Multi-Level Federalism. He is formerly a research fellow at the Vidhi Center for Legal Policy. His research was basically focused on constitutional law, federalism, and various aspects of center-state relation. So here we can see that when it comes to the common area of interest, both our speakers have a same area of interest, that is that federalism and center-state relations. So he has also co-authored reports for the 15th Finance Commission, and he has advised Government of India on various aspects of law through his legal research and legislative writings. He has done his bachelor's from Hadiyatullah National University, Raipur, and has achieved a university gold medal in jurisprudence and legal methodology. Also, he has extensively written on federalism, which of some has been printed by the leading national media houses, that is the Hindu, the Print, and the Economic Times. So thank you, ma'am and sir, for graciously accepting our invitation and giving your valuable time. Let me now give the platform to you, and please enlighten us over to the topic.
Great. Thank you. Thank you so much for that very warm welcome and that detailed introduction. It's great to be here with students on a Saturday morning. I'm always delighted to speak with students. So when Nikhil reached out to me and Mayuri and Kevin, Mayuri, who's the third author of the report, who's not part of this talk today, we were delighted. We just sort of took this up with both hands. Kevin, do you want to start?
Yeah, I'll speak first. You can share the PPT. Yeah.
Just 1 second. Is this visible?
Yeah, I can see it.
Great. Then purely in terms of housekeeping, what we plan to do is Kevin will start with the presentation and take you through the initial parts where he sets up the background for the federal structure of India, how we started our research. That's the sort of background Kevin's going to give. And Kevin, I think you're going to take around 10 to 15 minutes, after which I think we should pause for a bit. And if any of you have any questions, please feel free to ask at the 10 to 15 minute mark whenever Kevin is done with his part, after which I take over. I take you through the rest of the report. And then, of course, we can again take a pause at maybe the 30-minute mark where all of you can ask questions. So we don't want this to be a one-way street where everybody asks questions only at the end of it. I think it would be major information overload if you get to ask questions only after the entire talk is done. So yeah, I think let's break at 15 or 20 minutes and then we can have a small Q&A chat, if that sounds good to everyone. Kevin, I think you could jump in straight.
Yeah, sure. Hi, good morning, everyone. Just wanted to echo Ritvika at the start. I too am delighted to be here. Thank you for the introduction and the invitation. We have been working on this topic and topics like these for a few years now, and we're quite delighted to speak about it and hopefully some of you perhaps have read the report as well. We're open to questions beyond the presentation as well, if you have any. But okay, without further ado, let's get to it. So as Ritvika mentioned, I mean, just a broad overview of what we're going to do over the next hour. I'm going to be speaking on the first bullet point that you see, fiscal federal architecture under the Constitution. So that's about sort of the broader picture before we go specifically into Article 282 and centrally sponsored schemes. Then Ritvika would be doing the drafting history of those provisions and how it has been used post-independence. How has it been like in practice? And she's going to begin with how Article 282 can be, perhaps should be interpreted. And I will also, I will continue from that point and go on to recommendation. Whenever we switch speakers, as she mentioned, we would take questions. Okay, so we can go to the next slide now. Yeah, thank you. So just a second before I get into just the federal structure in the Constitution generally, which I'm sure many of you are aware of, we began with this topic thinking about all of these schemes, you know, and these centrally sponsored schemes, they're often in the news. You might have heard of many of them. They're quite famous, like the Swachh Bharat mission, the midday meals, Anganwadis, you know, Ayushman Bharat. There's so many examples. We don't often hear of them in constitutional law contexts, however, and we'll kind of get into why it is actually very relevant from that perspective also. So for the federal structure within the Constitution, as we're aware, I mean, there is a government and a legislature at the central level in New Delhi. This is the government of India and parliament. And at every state, we have the state executive, which is state governments, and state legislatures, including legislative assemblies and legislative councils in some states. This structure is provided in the Constitution itself under Article 246, right, with the 7th schedule. The 7th schedule, as I'm sure you're aware, has 3 lists: the union list, the state list, and the concurrent list. Over the union list, the center, meaning the executive as well as the legislature, have exclusive powers. It includes matters like defense, foreign relations, and the like. Over the state list, it is the states, which, of course, and the state legislature, which have exclusive competence, and these include topics like police, agriculture, public health, order, etc. And then you have the concurrent list, over which the center and the states share competence on a case-by-case basis. Now, this is, of course, on one part is the Constitution dividing the government and the legislature across 2 levels, but and assigning specific fields as saying, this is your responsibility, this is ours, this is what it is doing. But in order to really look at what the Constitution is trying to do, it's not just saying that there are these responsibilities that you have. Not for these responsibilities to be meaningfully exercised, each level of government needs to have enough money in order to do it. So it's one thing to say you have responsibility over police, but if you don't have the resources to maintain a force, to pay their salaries and all kinds of similar expenses, it's no good just having those responsibilities, which is why understanding the fiscal relations, who has the money, how much money does each level have, what are the mechanisms in which shared, also becomes very crucial to really understand the federal structure. And that gets me to the last 2-3 points on this slide, which is that the way in which these powers are divided, it's so the center has the greater revenue raising power. So it has the more broad-based taxes, like tax, non-corporation tax, customs duties, that kind of thing. Whereas the states have tax bases which are relatively less lucrative. This isn't something which has just emerged as a but as we are saying in this slide itself, this is literally written into the Constitution. This was a deliberate choice. On the one hand, the center has more revenue raising powers, but it is states which have major expenditure responsibilities. Topics like public health, agriculture, police, these significant investment. That's what creates a vertical fiscal imbalance. It's a bit of a technical, this is between the center and the states, and it's a fiscal, it's a money related imbalance. Balance is specifically that the level which has more to spend on has less money to spend. The Constitution is cognizant of this, and it creates mechanisms, ways of transferring between these two levels in for this. Next slide, please.
Let me just stop resharing and share this again because yeah, there's very, very artistically drawn thing on the screen and which I didn't do. I did not do that. Let me reshare this. I don't know how that happened. It's gone, right?
No.
Yes, ma'am.
Perfect. Yeah, sorry for the inconvenience.
No, yeah, so that's fine. So come to this mechanism now of how this money is shared. We 12 of the Constitution, which is finance, property, contracts, and suits. And it has a bunch of things regarding the financial relations between the two levels of government. So you have Articles 268 to 281, which is titled Distribution of Revenues between the Union and the States. You have Articles 282 to 291, which cover certain so-called miscellaneous provisions. And before getting into each of these articles, I'd just start with 80. So Article 80 is regarding the Finance Committee, which is in the news every now and then. It's a technocratic body, which is to say that it constitutes of experts, economists usually, and the like, appointed by the central government, the president, and it is every 5 years to make recommendations regarding intergovernmental transfers for a period of 5 years. So the latest Finance Commission, for example, was the 15th Finance Commission, which for the years 2021 to 2026. So their recommendations will hold ground until 2000. Before we arrive at probably around 2004, 25, have the 16th Finance be appointed, they would make recommendations. So that then gets me to the next slide, please, Ritika, which gets us into what does the Finance Commission do? How does it effectuate? So there are three main routes, and there are some types within these routes. So you have Article 270, Article 275, and 282. Article 2 about tax devolution. For the distribution of taxes that are levied and collected by the union. So the distribution of that between the union and the state. So there is a so-called divisible pool of. So as I said, the center has the greater of taxes, but the Finance Commission, after looking at numbers, speaking to states, applying a bunch of formulas, it comes up with a number, a percentage for devolution. So the latest numbers are, for example, the 15th Finance Commission said that the states should have a 41% share of the central taxes. So here, when I say states, I mean states as a whole. So you have the center and the states as a whole on the other. That's your vertical devolution. Recommendation to the center. And while these aren't technically binding recommendations, as a matter of convention, the center listens to most of the recommendations of the Finance Commission, especially the major ones. This is only, which is how many do states as a whole get from the center, how much of the proportion of it. This, how does that amount, that 41% that I just mentioned, how is it divided across? Because as you know, state area in terms of resources, wealth, all kinds of things.
Kevin, sorry, your internet's really breaking up. It's yeah, your internet's been breaking up. You just suddenly freeze for a second or two. Could you just check one if everything's okay?
Sorry.
I mean, you're audible, but you're sort of breaking in between.
I see. No, that's That's very odd. Working so far. Can you hear me now? I can try changing my internet source.
Yeah, maybe just try something because yeah. I hope it's not just me who's facing that issue with
No, okay.
Kevin's.
Change it. Apologies. 1 second. Just give me a minute. My internet source. Okay, I have changed my internet source. I don't know if this is better. I can maybe try turning off my video if it still doesn't work at all.
Yeah.
What
Just
do you?
maybe you could resume and we'll see where we are in the next couple of minutes.
Sure. Yeah, I'm really sorry about this. I don't know. This internet was fine. Like been using it every day in the last 2-3 weeks, but these things with work from
These
home.
things tend to happen.
But yeah, please let me know. I will switch off my video if that continues to be an issue.
Sure.
Right. So yeah, so as I was saying, the second question under Article 270 is how do we divide this money between the states? And again, the Finance Commission comes up with formulas and it gives different weightage to different criteria. So the 15th Finance Commission, for example, in determining which state should get how much, came up with criteria including population, area, forest cover, income distance, which is the per capita income compared to one state compared to the average across states, the demographic performance, as in are they taking efforts to reduce their birth rate, and the tax effort, which is how much are states doing the fiscally responsible thing of increasing taxes within their own jurisdictions in order to kind of reward performance, that the states which are more fiscally prudent get more money via the Finance Commission as well. So you can see that it's a combination of performance-based criteria as well as equity and need-based criteria. This might be a bit technical. I'm happy to take questions, of course. So that's on Article 270. And the money that you get via Article 270 as a state is unconditional, which is to say that it is up to you as to how you want to use that money. For which specific, do you want to use it for police, for agriculture, for your power sector, for land? It's up to you. And that money is yours to do as you please with. Article 270 is different. It's similar to 270 in the sense that the Finance Commission is also mandated to make recommendations regarding Article 275, but these are, rather than a percentage in the sense of devolution, these are made in the way of grants. And the term that the Constitution uses is grants in aid, to be made by the Union to the states. And these grants in aid, again, are of several types. So you have a revenue deficit grant, you have sector specific grants, including for health, agriculture, power sector reforms, etc. You have grants related to disaster management, grants related to local government as well. And again, this varies across states, and this is a very state specific thing. So it's not necessary that every state might get a grant in every single category. But the Finance Commission basically does its research, it carries consultations with various states, and that's how it comes to these conclusions. So these are two of the major routes through which money is transferred from the center to the states. But then you have Article 282, which is what we're really going to focus on, especially Ritvika, in this presentation, which is another route through which money is transferred by the center to the states. And these are basically grants that can be made by the union or by a state for any public purpose, even beyond their respective legislative competence. So what does that mean? It means all of those schemes that I mentioned at the start, like the midday meal scheme and all of those, are basically centrally sponsored schemes under Article 282. So the center can make this scheme so long as it's under a public purpose, which isn't defined very narrowly. So most of these things do fall under public purposes, of course, like health and education and health insurance and the like. And it makes these grants to states, and these grants are often conditional. Now, A point which I missed making in the context of Article 275 was that those grants are also conditional. So a conditional grant would mean, for example, that, okay, we will give you so many crores worth of grant for your power sector, provided you undertake these reforms in your power sector, right? So long as you stop giving freebies, for example. Or to take an example from 10, 15 years ago, the Finance Commission wanted states to pass their own Fiscal Responsibility and Budget Management Act, basically commit to a consistent debt level, etc. And basically it works like this, that if you do this, then this is the incentive, you get this grant. So this is an example of a conditional grant. You have to meet this condition in order to receive this grant. And in the case of Article 275 grants, it is the Finance Commission which recommends these conditions. But in the case of grants under Article 282, which is centrally sponsored schemes, it is the center that determines these conditions. And these conditions often we observe, and Ritvika will get into this more, reflect the political priorities of the party in power at the center, for example. And because of the imbalance, because states need money, states often end up having to conform to these conditions in order to avail of this money. So that kind of affects the state's policy options, because it might want to do a particular policy field in a certain way, but it's limited because if it wants money, then it'll have to do it in the way that is mandated by the center as part of the scheme. So I'll stop here. And if anyone has any questions on anything that I said, please feel free to ask, after which Ritvika will go more into Article 282. And sorry once again for the network thing. I hope it's better now. Yeah.
It's better. It's actually much better now. Or so I feel.
Yes, participants, you can now type your questions in the chat box.
I'm happy
you could just turn on your camera and speak into the camera.
Yeah, if you would want, you can unmute yourself and please ask the question yourself.
Yeah, someone sent me a question in direct message as well. I mean, I would prefer if you could just say it openly, because otherwise I'll just be spending time reading your question, if that's okay.
So I think you can read the question because none of us.
Yeah, sure. Okay, that's fine. Okay, so it's a slightly long question. So it says, the Finance Commission is an important body, especially with respect to the fiscal relationship between the states and the center. However, it's not a permanent body like the GST Council. The Finance Commission can further asymmetric federalism by granting a different amount of grants to different states based on various factors, whereas in the GST Council, all states have equal votes. So do you think we need a body like the GST Council to strengthen asymmetric federalism? Yeah, that's a great question. I didn't really get into the GST Council aspect so much, but since you brought this up, sorry, I didn't mention, this is a question by Nikhil. Yeah, so since you brought this up, Nikhil, this question of imbalance, right? If anything, it has been exacerbated ever since the GST regime came about from around 2017 onwards. And the GST Council makes for a very interesting comparison with the Finance Commission. You're absolutely right. The Finance Commission is not permanent. It's for a very specific purpose, and it gets disbanded after that purpose, and then it gets reconstituted with new people. The GST Council is permanent. Not just that, another difference is that the Finance Commission has technocrats, it has experts, whereas the GST Council is representative, which means it's got the finance ministers of all the states and of the center. So these are slightly different types of bodies, and yet the GST Council is a very new body, right? So it's barely 4 to 5 years old. The Finance Commission is a very old body, but not permanent. There have been some calls for reform. Maybe you're referring to something perhaps you've read, or because I've certainly heard this being mentioned, for example, by N.K. Singh, the chairperson of the 15th Finance Commission. He's mentioned in several speeches last year that India should consider having a permanent Finance Commission, because the Finance Commission makes grants based on estimates of revenue. Like it estimates that the state would be earning this much revenue and therefore it would need this much assistance. But actually, the revenue that a state is earning is so linked to the decision that the GST Council makes on the rate of taxation. And so the argument is that if you have both bodies that are permanent, then they could calibrate their recommendations based on each other's decisions. So there is a strong case to be made for that. So it's a very good point. But yeah, as of now, certainly that is not the case. I see a second question. I'll take this one also by Ishan, who says, how can they have a check on their flow of revenues or to check whether is it used in a right manner or not? So I suppose you mean the Finance Commission over here. And you're right that the finance, I mean, if your implication is that as of now, they don't have a mechanism, which is true. This is part of what, yeah, the Finance Commission is really only an advisory body. It has an outsized importance because by practice, it is the central government and parliament that listens to it and implements this. But the Finance Commission, the only way in which it can check implementation of its grants and whether it's really happening in spirit is that, you know, the next Finance Commission always takes into account what the previous Finance Commission's recommendations were and how the numbers played out in the last 5 years. So the only way in which some kind of consequences might carry forward is one Finance Commission might be like, oh, okay, this was that Finance Commission's recommendation. This is how it played out. And now we will make changes accordingly. But that's the only way. There is no sort of direct way. Of course, in the case of Article 275 and conditional grants, assuming that the center implements it in spirit, hopefully the states are getting that money only if those conditions are met. So that's a kind of precondition. So that should hopefully operate as a kind of check, but it's not a very specific system. It's very indirect in that sense. Yeah.
Just 2 points on that, particularly on the point of how, if at all, the Finance Commission maintains a check on whether certain targets were met or not. So and Kevin, this is where I'll also come in when I talk about the drafting of these provisions. So when Article 280 was being deliberated in the Constituent Assembly debates, one of the powers that the Finance Commission could have potentially gotten was that of a quasi-adjudicatory body. But eventually, this was not supposed to be an institution that would sit in judgment over the center or the states. It was supposed to ensure that states and center, whatever the intergovernmental means of transfer or scheme of transfer was, that is something that keeps happening seamlessly. And that was sort of the purpose of the Finance Commission in the first place. And this system, this arrangement of revenues being met, of targets being met, was supposed to happen seamlessly. Nobody was supposed to sit in judgment over that. The other thing on the Finance Commission being a temporary body, which is not akin to the GST Council in that way, Kevin, I think you and I have also discussed this once previously, the 5 years for which, at the end of which the Finance Commission eventually submits its report. Those 5 years are practically spent on researching, spent on talking to representatives of the states and trying to get a sense of what exactly their needs might be. And I think that sort of gets reflected in the eventual report also. We've read the 15, I mean, I haven't read it in detail, but Kevin has. The 15th Finance Commission actually alludes to a lot of evidence that representatives of the Finance Commission collect during those 5 years. So I can fully imagine why it's not a permanent body sitting every day, sitting on all these 5 years, because a major part of those 5 years are spent on working on the recommendations that eventually come out. So possibly that's a very practical point, but a very valid point, on potentially why the Finance Commission doesn't sit permanently. Do we have other questions?
No, ma'am, I think that's all.
Should I proceed then or to the next part? Yeah, 1 second. So thanks, Kevin. You very helpfully set out the backdrop for these 3 provisions that are going to form part of our discussion going forward. 1 second. Yeah. So I think a good thing at this point, a good segue from here would be into the drafting history of the provisions on which establish the fiscal relations between the center and the states. How exactly did Articles 270, 275, and 282 come to be? Most of my discussion is going to be on the chapter on fiscal relations, on financial relations between the center and the state as a whole, and not on specific provisions. But yes, there is going to be a focus on intergovernmental transfers, particularly Articles 275 and Article 282. So our historical analysis for this report comprised a survey of the texts that I mentioned right on top, which are the report of the Joint Committee on Indian Constitutional Reform, which preceded the Government of India Act 1935, the report of the Expert Committee on Financial Provisions of the Union Constitution, and the Constituent Assembly debates. Now, the report of the Expert Committee on Financial Provisions of the Union Constitution was one of several committees which were constituted by the Constituent Assembly to look into specific parts of constitution framing. So I think, if I recall correctly, there were about 22 such committees that were formed, and the Expert Committee on Financial Provisions was one of them. So if you look at the Constituent Assembly debates on financial provisions in the Indian Constitution, there weren't vehement debates on a lot of aspects, but yes, the question of intergovernmental transfers was debated in some detail. I've culled out some key observations from this historical aspect on 4 points. One is on expenditure responsibilities. The other is on financial support to provinces. The third is on the role of the Finance Commission, which has been alluded to by Kevin, and we've discussed this in some detail already. And the last is on Article 282, because Article 282 eventually is the crux of the research that we did for this report. So I'll jump straight into the point on expenditure responsibilities. So the Joint Committee report, the one that preceded the enactment of the Government of India Act, it gave crucial insights into the factors that informed the scheme of financial relations between the Union and the provinces. Now, the committee took note of two very, very pertinent problems at the time of the drafting of the Constitution. One was the fact that in a lot of situations, there were two authorities: the government of the Union, the government of the Federation, which is basically the central government, and the government of the units of the provinces, which is the state governments, as we now call them. Both were raising money from the same body of taxpayers. So one way of simplifying this would have been to provide separate fields of taxation to both these tiers of government. The issue with that would have been that the revenues which would have accrued to the state governments or to the provinces would have been very little. They would not have helped the states to meet their needs. And in fact, there is a very, very crucial line in the JCR, in the Joint Committee report, which says that the provinces have an almost inexhaustible field for the development of social services, while the demands on the center were more constant in character. This sort of also ties back to the way in which the 7th schedule eventually turned out to be. So if you look at the 7th schedule, the kind of entries that go into list 1, list 2, and list 3, center, state, and concurrent list, you'll see that the union list mentions subjects of national importance, which is defense, foreign relations, to name a few, while the state list has enumerated subjects which are of local and regional importance, like public health, local governments, police, agriculture, and other subjects which are associated with the development and welfare of the citizens. So the JCR is very cognizant of the fact that the state list subjects are something that are going to require sustained attention at the part of the states. And the field of expenditure for the state governments is inexhaustible, if you think about it, the kind of subjects that there are in the second list. At which point we come to the aspect on financial support to provinces. Now, if the realm of expenditure, if the kind of subjects that the state government will have to spend on is vast and inexhaustible, of course, the provinces or the states will need some support. Also, let's not forget that this was a point in time, this was a point in history where we were coming fresh off from the scars of partition. There were historical, there were socioeconomic factors which meant, which sort of translated into need for greater support for the provinces. And again, the committee very categorically noted that during the developmental stages of the country, it will be necessary for the center to make specific purpose grants to the provinces from time to time. So it's quite evident that the Constituent Assembly, the framers, the expert committee, all of them combined, I'm just going to use the framers as one catch-all term here, they were cognizant of the fact that provinces will need some support from the center. In fact, there were specific, very, very specific requests from certain provinces such as Odisha and Assam, in fact, even East Punjab and West Bengal. They asked for fixed amounts as grants during the deliberations in the Constituent Assembly debates, so as to further their cause, so as to further citizens' development at that given point in time. So after that, the other thing that was discussed was the role of the Finance Commission. So the expert committee that I just spoke about a couple of minutes back, the expert committee wanted to create a system which could be implemented automatically and without any friction or mutual interference between the state and the center. How could that potentially happen? They thought that if the Constitution lays down a scheme of intergovernmental transfers, tax devolution, and other sort of grants from the center to the states, they could have periodic review by an impartial body. They call it an impartial tribunal during the framing of the Constitution, but eventually it's not, the Finance Commission is not a tribunal. But they thought that if they could have an impartial body which undertakes periodic working of this fiscal scheme, that would do the job of ensuring a seamless working of these financial provisions of the Constitution. Eventually, this is the body that came to be known as the Finance Commission. Now, among the other functions, some of which, Kevin, you've discussed already, the major functions of the Finance Commission were included the allocation between the provinces of the shares of centrally administered taxes. If there's a centrally administered tax, how exactly is going to be shared between the provinces? And also, the other function was, of course, to consider applications for grants and aids for provinces. So if a particular province were to ask for a grant from the center, how exactly, what amount would be given to the state, for what purpose would it be given, how much of it is going to be tied and untied. All of these were going to happen based on the recommendations of the Finance Commission, which, as I said, was considered to be a body armed with technocrats, staffed with technocrats, and performing an impartial role, sitting above the center and the state. Now, the last bit that did not honestly get discussed in detail in the Constituent Assembly, but is very important for our purposes, is a discussion on Article 282. Now, quite blankly, I've actually written that there was no detailed conceptual discussion on this provision, and that's true. There was no detailed discussion on Article 282, the institutional mechanism which would facilitate a transfer from the center to the states under Article 282. And in fact, the only reference or the only discussion on Article 2, and in fact, that can't be called a discussion, but there was a remark that was made by Dr. Ambedkar while discussing some other provision of the Constitution. And I'll just read out that remark because it's sort of important here. Dr. Ambedkar said that Article 262 has a much wider scope compared to Article 275 because the Parliament is free to make grants on subjects outside of List 1 also under Article 282. So basically, Parliament was empowered to make grants under List 2 or List 3 subjects also under Article 282. However, one must recall that this reference, this particular argument that was furthered, or this particular view that was furthered by Dr. Ambedkar, was not in reference to a discussion on Article 282. Another provision was getting discussed, and this was sort of, I mean, I'm going to hazard and say this here. I'm going to take a leap and say this here. It was more of a chance remark on Article 282. And it wasn't a conceptual discussion on if the Parliament is empowered to make grants under List 2 and List 3 entries, what was the mechanism to do that? How is that going to happen? Who would have the final word on whether a particular grant can be made on public health by the center? So there were no conceptual discussions here. So yeah, this and broadly, the question of grants in aid, generally, whether under Article 275 or 282, and if anyone would be interested in reading these, the Constituent Assembly debates on these provisions, I must mention that Article 282 in the draft Constitution was numbered as Article 262. So yeah, the debate for this particular provision or for Article 275 will not be found exactly under those provisions. The numbering of the provisions changed eventually. So yeah, in sum, there were some discussions on specific aspects concerning financial relations, as well as the scope of the Finance Commission's roles and functions. But in sum, no suspicion was evinced on the part of the provinces that if the union is providing fiscal support to the provinces, there is going to come a day where the autonomy of the states on how much they can spend on subjects which are purely within their legislative competence, that autonomy will be hampered. In fact, as I said a couple of minutes back, some provinces specifically asked for fixed grants, so that considering their own backwardness, considering their own peculiar circumstances, in some cases like Assam, considering their topography also, they had asked for specific grants so as to reach a certain minimum level of development. So there was no suspicion on the part of the provinces. In fact, if anybody is interested, I'm guessing some of you would have already read it. Granville Austin, in his the Cornerstone of a Nation, that book, the first book he's written on the Indian Constitution, he provides a very interesting, very succinct description of how exactly the discussion on financial provisions of the Constitution, how that panned out. So please do give it a read if anybody is interested. So this is broadly what I had on the drafting history of the financial provisions, which now brings me to the next part on how Article 282 has worked in practice. So at this point, I genuinely feel we've been talking a lot about Article 282, but I would just want to also read it out at this point, because I don't think any of us have, either me or Kevin, have done that at this point. So what Article 282 says is, the union, the marginal roads as expenditure defrayable by the union or a state out of its revenues. And what Article 282 says is, the union or a state may make any grants for any public purpose, notwithstanding that the purpose is not one with respect to which Parliament or the legislature of the state, as the case may be, may make laws. So I'll just sum it up. Anyway, it's a very short article. It's not a very long provision. The union or the state are empowered to make grants for any public purpose. Public purpose is sort of the key term here, notwithstanding that this public purpose is not one with respect to which the Parliament or the legislator is empowered to make laws. So so very simply put, the Parliament, using the power conferred on it by Article 282, the union can make grants under subjects which strictly fall under the competence of the state government. So Parliament, so the union making any grants towards public health and asking the states to actually implement those grants in a certain manner. This is where the whole point on tied and untied grants comes in. So how exactly did this article, how has this worked in practice? It's sort of impossible to talk about the working of Article 282 in practice without talking about the institution of the Planning Commission. The Planning Commission, as we know, is not a body which was established under the Constitution. The Constitution does not have any reference to the Planning Commission. Excuse me. The Planning Commission came into existence by means of a cabinet resolution in 1950. So bear with me for about 2 minutes, because there is some historical context to it as well. So soon after the Constitution came into force, India had independence. There was a model that Kevin has already spoken about. The model had envisaged interdependence between the union and the states to resolve issues of national importance, to achieve socio-economic progress. And of course, the finances here had to be handled based on some grants from the union to the states, and in some ways in which the states could, of course, raise revenues of their own. In the early 1950s, however, and this was soon after independence, there were issues in center-state coordination which began to emerge. At this point, the then Prime Minister Jawaharlal Nehru, who expressed concern about the apparent constraints on the central government to further socio-economic development in a welfare state, as major developmental subjects fell within the competence of the state governments. So as I keep saying, public health, agriculture, police, local governments, all of these fell within the competence of the state governments, which in a way meant that the center's power to do a lot of things in states, to do many undertake developmental projects in the states, was hampered by the scheme of the Constitution. So driven by this sentiment, the intention of having a planning commission was announced. And eventually this was this got established as an advisory body in 1950 through a cabinet resolution. I keep saying cabinet resolution time and again because as opposed to the Finance Commission, which is a body established, envisaged under the Constitution, the Planning Commission was the product of a cabinet resolution. Now, again, the constitution of the Finance Commission also, who exactly is going to man or woman the Finance Commission, is also provided for under the Constitution. The Planning Commission, what sort of staffing did the Finance Commission have? The Prime Minister was the ex officio chairperson of the Planning Commission, the Prime Minister. So you can see that the role of the government, of course, the government will play an outsized role in the working, in the day-to-day, in the decision-making of the Planning Commission, not day-to-day decision-making, but decision-making of the Planning Commission. The other members, who were the other members of the Planning Commission? They were either cabinet ministers or experts which were appointed by the Prime Minister. So essentially, the membership of the Finance Commission was coterminous with the term of the Prime Minister. And effectively, if you think about it, the commission was established as a unit of the central government, wherein the membership corresponded with the political cycles of whichever government was in power. So yes, even if I were to not say it explicitly, the Planning Commission will eventually have a political life of its own, and that will also get reflected in its decision making. So this is about the establishment of the Planning Commission and why did the Planning Commission get established in the first place? This is where that comes. Then what were the functions of the Planning Commission? So Planning Commission, and I'm sure everybody's read about this or they're familiar with the existence of something called the 5-year plans. The 5-year plans, of course, do not exist now. Did someone say something? No. Okay. So I'm sure everybody's familiar with the concept of 5-year plans. 5-year plans don't exist now because as of 2015, the Planning Commission ceased to exist. Sort of, I mean, not completely, but yes, no, we don't have the Planning Commission and the National Development Council now. We now have something called the Niti Aayog. Not exactly not exactly an exact replacement, but yes, the Planning Commission doesn't exist now. But what was the purpose? What was the function of the Planning Commission? The Planning Commission was tasked with, of course, formulating these 5-year plans. Besides that, on the question of grants in aid, the Planning Commission was tasked with giving recommendations on the magnitude of grants and loans which were to be provided to states for financing their expenditures on targeted interventions for socio-economic development. So, and one of the functions of the Planning Commission was, in fact, to approve the plan of each state and to also facilitate, advise on, and facilitate transfer of funds from the union to the states. These funds could both be tied grants from the center to the state as well as the untied grants under the plan. So again, it is crucial to mention that these transfers, which were being facilitated via the advice of the Planning Commission, they existed along with the transfers which were being made on the recommendations of the Finance Commission under Article 275. So what happened eventually was, now there is this Planning Commission, which is advising and sort of authorizing, sort of facilitating transfers to the states for meeting their plan goals. This came to be known as planned transfers. Now, planned transfers is sort of a term here, and I'll just take you to one chart that we had in our report. Maybe that will help. That will have a good pictorial representation of what I'm saying. And the Finance Commission transfers under Article 275, they came to be called non-planned transfers. So there is this distinction which does not exist anywhere in the Constitution or any text. But now there is this distinction between planned transfers via the Planning Commission and non-planned transfers via the Finance Commission. In fact, the institutionalization of this planned transfer was to such an extent that for the longest time, what exactly is going to be transferred to state as part of planned transfers was based on the request of a particular state. So if the state is asking for a certain X amount, Planning Commission is going to consider it. It'll either give it X or not give it X, but it will consider a lot of factors and then arrive at a certain figure. But the institutionalization of this thing, of planned transfers was to such an extent that after a point, I think sometime in 1969, they actually devised a formula that we'll figure out what exactly is the population of state, what is the per capita income in that state, what are the special, what if it's a particularly backward state. So based on several variables that went into this formula, ultimately the planning commission kept transferring all of these funds to the states. I'll just also take you to sorry, one second. I'll take you to one particular chart in the report, which might help you understand this. Sorry, I'm so sorry for the disturbance. Is this visible?
Yes.
Yeah. So one second. Eventually, if you think about the government budget normally will, of course, have something called receipts and will have something called expenditures. So as part of the expenditures, again, as part of the government expenditures, while the Planning Commission was in existence, there was something called plan expenditure and something called non-plan expenditure. As part of the plan expenditure, if you see, this plan expenditure has something called central plan and central assistance to the state plan or central assistance.
Ritvika, so I just want, could you zoom it a little more? Someone's just mentioned
sure.
in the chat. Yeah.
Yes.
Sorry.
Oops. Okay. Oh, one second. Oops. Not the ideal. Is this still visible?
Yeah, I think it's better.
Okay. I'm so sorry for that. Let me just, I'm sure it's still visible. Yeah. So if you look at it, there is this budget expenditure prior to 2017. And I say prior to 2017 because as we now know, the Planning Commission doesn't exist anymore. And we now have a completely different way of understanding budget heads. But yes, as part of the budget expenditure, there is something called the plan expenditure and the non-plan expenditure. There used to be something on plan and non-plan expenditure. As part of the plan expenditure, we have something called the central plan and the central assistance to state plan. Now, central assistance to state plan, as the name suggests, is the sort of assistance that is being given from the central government to the states. This is where something that's relevant to our discussion comes in. And we have the center giving something, center giving grants or center providing assistance to the states via centrally sponsored schemes and block grants. So eventually, in this entire scheme of things, we now have something called centrally sponsored schemes, which are an institutionally recognized means of the center giving assistance to the states. And this existed, this sort of budget division of budget heads existed till 2017, and centrally sponsored schemes were a validly recognized means of giving grants to the state governments. For several purposes, a lot of which were on matters which strictly fell within the competence of the state governments. Now, all of this, as I said, existed till about 2015-17. In 2015, the Planning Commission was disbanded. The 5-year plans were discontinued. And now the budget heads do not have something called a distinction between plan expenditure and non-plan expenditure. However, that does not mean that centrally sponsored schemes have vanished. In fact, what has now happened is the Planning Commission as a facilitating mechanism has gone, but assistance from the center to the states for centrally sponsored schemes goes via specific central ministries. So I'll just take you to this second chart and then we'll be done with charts and I'll not do this. So the other thing is currently the budget heads are divided under, there's something called central expenditure and transfers. Now, central expenditure has certain heads like establishment expenditures. Establishment expenditures are generally recurring expenditures, central sector schemes and projects and other central expenditure. Transfers under the current division of budget heads is again via centrally sponsored schemes, finance commission transfers and other transfers. Now, I want to bring your attention to the transfers bit here. It's visible, right? Yeah. Under transfers, we have something called centrally sponsored schemes. We have finance commission transfers, which are the 275 transfers, Article 275 transfers, and other transfers as the case may be. So again, the institutionalization of CSSs still exists. CSSs are again being used as a means to give grants from the center to the state government. And even though the planning commission has gone, the planning commission doesn't exist, these transfers still exist, mostly being tied transfers because centrally sponsored schemes have certain conditions attached to them, based on which the states can avail the money that is coming from the center. Now, of course, there are certain issues with that. I'll take you back to the presentation. Right. So what exactly are the issues with centrally sponsored schemes? I think that would be best illustrated if we use an example of some sort. So let's think about something like the National Health Mission. The National Health Mission, as we know, is possibly one of the most detailed missions, programs which have begun on several aspects of public health. So even if you were to do some very basic search on the National Health Mission on their website, you'll realize that the National Health Mission has far too many sub-schemes. And considering that public health is a state subject, the possibility of some of those sub-schemes under the Central National Health Mission not overlapping with another state health mission dealing with the same subject matter is very unlikely. I'll not take too long because I also understand this, it's 12:30 already. But yes, one major problem with centrally sponsored schemes is this, that it has a one-size-fits-all mechanism. So a centrally sponsored scheme which is made in Delhi for Maharashtra is also supposed to apply to, let's say, an Orissa, without really taking into account that the peculiar needs of Maharashtra might be very different from the peculiar needs of Orissa, considering the backwardness of a particular region, the topography, the geography of a particular region. So yes, it has a one-size-fits-all mechanism. The other thing is centrally sponsored schemes progressively erode the jurisdiction and the authority and initiative of states in their constitutionally defined spheres. So centrally sponsored schemes are part funded by the state and the center. So the center is, let's say, if it's providing 50% of the states, the remaining 50% of the grant has to be made good by the state government. Now again, considering it's a one-size-fits-all mechanism, Maharashtra might be able to foot that 50% bill very easily, while let's say a Bihar might not be able to do that. So in that case, a backward state eventually becomes even more backward if it's being asked to give 50% of its money for a scheme that has been floated by the center. I've already spoken about the point on potential overlaps. Now, considering that there are all these criticisms and all these issues with centrally sponsored schemes, it's not as if reforms have not been initiated in this regard. In fact, in 2015, there was a subcommittee of chief ministers from across states who sat on this issue and they deliberated what can be done. So since the Planning Commission came into existence till now, several schemes had been floated, some 150 odd schemes as per a particular government estimate, I think sometime in the early 2000s. So the subcommittee thought a good idea would be to club a lot of these schemes and bring them under 28 schemes in total. So currently, these 28 schemes, I've taken you to the next slide. This subcommittee, what it did was, it clubbed all these 100 odd or 200 odd schemes into 28 and divided them in these categories. So something called core of the core schemes, optional schemes for other category, general category states, and then core schemes. Now, how do these schemes differ? The core of the core schemes are those schemes which are so inherently important to the needs of a state that these are 100% funded by the center. As you go down, the funding ratio of the center and the state sort of vary. So for optional schemes, for Northeastern and Himalayan states, again, Northeastern, Himalayan, because of geography, possibly their financial needs are more, the center is willing to foot 80% of the bill, for the with 20% coming from the state. For optional schemes, general category, 50-50 division of funds between the center and the state. And that is sort of that is a sort of funding division between the center and the state. Yeah. And this is where we are at currently in terms of how centrally sponsored schemes are being worked. Now, one would assume that now, considering 200 odd schemes have been brought under 28 schemes, things are fine, except that they aren't, because all of these 28 schemes have so many sub schemes within them. It has now become virtually impossible to find out how many centrally sponsored schemes actually exist. So eventually what happened was, it's not as if those 28 schemes, those 100 odd schemes were rationalized. They were just compressed and brought into 28. And if I think, and Kevin, you could correct me if I'm wrong here, I think in the 15th Finance Commission report, the Department of Expenditure had said that even despite this rationalization, some 150 odd schemes still exist. And it's still very difficult to ascertain what exactly is the correct number of schemes there. So I'll stop here. And Kevin, you could then take over and talk about how exactly 282 ought to be interpreted in a way that the concerns that have arisen because of the implementation of 282 a certain way can be quelled. So, okay, I think it's also helpful to just summarize where we are, right? So I discussed three things. One is on the drafting history of the financial provisions chapter, wherein it was envisaged that some grants will be made from the center to the states. However, there was no suspicion on parts of the state that these grants would somehow usurp the autonomy of the states on their respective subject matters. But when the Planning Commission came into picture post-independence and CSSs started to get authorized and implemented via Article 282, we saw that the center has been floating around several centrally sponsored schemes which strictly fall within the legislative competence of the state. One very important, the best example here will be the National Health Mission, which is a central mission, even though public health strictly falls within the legislative competence under states. It's in list 2. So if 282, which is a very broadly worded provision, is being used a certain way by which the parliament can authorize schemes on strictly state subjects, can we have an alternative interpretation of Article 282, which does not upend the federal balance between the center and the state? I'll stop here and we could potentially take some questions if there are any.
Yes. So participants, you can type your questions or you can unmute if you want. Ma'am, by the time they type their questions, I have a question. So, yes. So ma'am, don't you think centrally sponsored schemes are budget-wise better than states making their own?
So, I'm guessing your point is that considering some states only have to fit, let's say if there's an 80-20 cost division, states only have to foot 20% of the bill. I think that's what your question is. So 2 or 3 points here. One is, well, yes, cost-wise, possibly, that makes a lot of sense. All you have to do is just give 20% of the cost of a particular scheme, and the rest 80% is going to come from the state. However, let's not forget that a lot of these schemes are strictly on state-specific subjects, which means that the terms of this grant, what exactly states are supposed to do to actually get that grant is coming from the center. So it's basically a unit of government that is sitting in Delhi telling you what to do in specific districts within your state. So it's also an autonomy question. Ultimately, states are being told that you have to spend on X when actually a state might want to spend on Y. That's one of the concerns. The other thing is, post this rationalization of schemes and bringing this into 28 schemes, these differing funding patterns have happened. Now, this 80-20, as I was saying, might work for a particular state. 80-20 might not work for all the states. And I think this is, if some literature has also, some study has also gone into this, that for backward states, any sort of cost division actually hampers them a lot, because they might not be in a position to even foot that 20% bill. So for all they want, centers should possibly not be floating any schemes altogether. So it's a question of autonomy on the kind of work a state wants to undertake on subjects that are strictly within its legislative competence, and also what exactly is the peculiar need of a state. So the biggest problem here is the one size fits all approach of centrally sponsored schemes. Having said that, I'll just park this thought here. In some cases, centrally sponsored schemes have actually played a more positive role in furthering developmental causes in certain states. I can get back to you with examples. Nothing's coming to my mind right now, but I'm certain in some instances, centrally sponsored schemes have actually played a positive role in developmental causes in states. I think there are 2 questions in the chat box.
Yes, ma'am. I'll read out to you. So first is by Nikhil. He says that centrally sponsored scheme seems to be a mechanism to enhance the welfaristic role of the state. However, do you think that centrally sponsored schemes have now become a substitute for many of the state government schemes?
Nikhil, actually, I'm totally with you on that. In fact, that is the precise reason for which the Planning Commission was set up. 282 began to be used for authorizing CSSs, which was to enhance the welfarist role of the state. All of that very well taken. And as I was saying, this is precisely why the PC was set up in the first place. However, do you think that centrally sponsored schemes have now become a substitute to many of the state government schemes? Not substitutes as such. So again, like there are a lot of political considerations also here, where a state, the center would want to further a particular scheme and just sort of shove it down the state's throats. I won't say they've become substitutes, but yes, there is a significant amount of significant extent of overlap between a centrally sponsored scheme and what potentially a state is already doing on public health or agriculture. And if there is a sort of overlap, let's not forget that these are conditional grants. States are going to get the center's money only after fulfilling certain conditions which are part of that scheme, part of that memorandum of understanding through which the scheme is effectuated. So yes, one is there are a lot of political considerations which possibly mean that the center wants to do something and push states into doing those exact things under a particular scheme. The other thing is, more than substitute, I would say there are some overlaps. The third thing is, you would believe that yes, possibly the sort of point that also came up in the previous question, this is a welfarist measure for the state. But again, if the grant is so tight and is so conditional on states doing XYZ to get a certain amount of money, then it becomes a little counterproductive. Then it's just very counterproductive. It's not exactly in the interest of the state, but it's actually sort of arm twisting states into doing things which they might have not done. So yeah, that's that.
Yes, ma'am. One more question is from Ishan Singh.
One other question.
Yes, 2 more questions.
Yeah, I'll just take Ishan's question. Do the states get their revenue all at once or in installments according to their need? Kevin, would you have an answer to that? I am not very sure about that.
Yeah, no, I'm happy to take that. So Ishan, it really depends on the scheme, and different schemes are structured differently. So I can give you an example, not of a particular scheme, but like, how it works sometimes is that the center would say, okay, say for this particular scheme, we are going to structure our funding in this way, that we've divided it into phases. We'll give you money for this part of the work, say for constructing public washrooms and the like, etc. And then you will have to basically provide us with what is called a utilization certificate, which is kind of like a proof that, yes, I have used these funds, I have done this part of the work, and therefore I am eligible to get the next bit of funds. So there's like a lot of paperwork that is kind of involved in this, and it varies across schemes, the kind of requirements that are there, but this is often part of the conditionality. I was talking about conditions with the example of undertaking reforms, but other conditionalities include, for example, auditing the accounts and the like. So typically you don't get all the money all at once. Typically it is structured, and as you keep meeting conditions, as you keep fulfilling the purpose for which the first tranche of money was given, that's when you become eligible for the next. So it's a very long drawn sort of waiting game with like a lot of paperwork involved. Yeah.
which I think also ties back to the point of, not exactly arm twisting might be too strong a term, but yes, tying states into a lot of conditions for a grant, which again, so giving them a grant, but tying them in so many conditions, which makes it very difficult to comply. So yeah, I think that also is sort of standing out over there. I think we have another question from Shreya. How does Article 2, I'll just read this out. How does Article 282 come into the picture when the finance commissions are making recommendations for financial grants for the third tier of government? Given that the third tier of governments came into being only after the 73rd and 74th amendments. Again, Kevin, have you read anything particularly in Finance Commission reports on CSSs and 282? Sorry, 282 and local governments?
Yeah, so I mean, more generally on finance commissions and local governments, you would see in Article 280, which is the provision that establishes the Finance Commission. It is specifically part of the Finance Commission's mandate, as your question also recognizes, Shreya, that the Finance Commission is supposed to make grants to augment the consolidated fund of a state in a way that they can bolster their local governments. And finance commissions do make this grant under Article 275. I listed that as one example of a specific type of grant that the Finance Commission does. Article 282, much like in every other example, kind of operates parallelly with this, so you have one route, which is through the Finance Commission, where the Article 280 itself says this is what you're supposed to do, and then they come up with these conditions. But as you know from the wording of Article 282, that can be a grant for any public purpose, and bolstering a local government is part of a public purpose. So there can very much be centrally sponsored schemes targeting local governments, as well as Finance Commission schemes targeting local governments. And you mentioned the 73rd and 74th Amendment. That's right. They got, I mean, these local bodies got constitutional recognition with those amendments. And it was at that time itself, I believe, that amendment was made to Article 280 as well, that the Finance Commission specifically look at their funding also. So yeah, I mean, these can exist parallelly, and this is part of the overlap, I think, that Ritvika was mentioning. Okay, I think I can go on to my part then.
Yes.
Yeah. Okay, yeah, thanks a lot for all of those questions. And I see we're running a bit short on time, so I'll try to be brief and get some more questions probably at the end. We see in this slide over here, how should Article 282 be interpreted? I mean, that's the broad theme of what I'm going to be talking about. But the distinction between 275 and 282, as I had touched upon initially, just kind of revising that really quickly, we see how Article 275 are grants which are made through the Finance Commission's recommendations, whereas 282 is truly discretionary. Discretionary, by which we mean that the center can decide upon its discretion whatever kind of scheme it wants to do. And as Ritvika went through in detail on the history, there was a kind of nearly unsaid understanding that this would be like a miscellaneous, like a top up, like an extra thing once the regular routes are exhausted. That sense also comes from the headings. As I remarked upon earlier, 282 is a miscellaneous provision as opposed to one under the distribution of revenues. And you can probably go through the rest that is there in this slide as well, which just goes into like these differences. And as we see 282, there was the Planning Commission, which was a parallel structure, and so on. So for this, okay, we can go to the next slide. Thanks. So as Ritvika went through in detail, both from the history as well as the practice, these two things were going on parallelly, are going on parallelly. Until 2014, 2015, there was also parallel institutions with the Planning Commission involved. But there were tensions, and there are tensions about centrally sponsored schemes. And before I get into what happened with the 9th Finance Commission, I just wanted to also say, with some of the questions we received just now a few minutes ago about, don't centrally sponsored schemes do some good? Well, absolutely they do. I think the problem also is that since things have been happening a particular way, it's hard to imagine a counterfactual where a centrally sponsored scheme might have been designed differently in a way that actually tries to bolster and capacity build the state's own ability to actually meet their own needs. And this actually goes two ways, because what happens is it's not just that the center is able to dictate the agenda, but on the other side of the spectrum, and scholars have noted this, that states also get used to the idea of the agenda being dictated to them. If you look at it in terms of incentives, states are not incentivized in this structure to invest in their own planning capabilities, because they know that they will get money via following the center's plan for them, and thus there is no incentive for them to rise to their full potential as independent rungs in our federal structure. I just wanted to make that point quickly. So there are these issues, and constitutionally, in terms of interpretation of it, which is what, of course, we are focusing on, and trying to get that to go hand in hand with the more practical issues, we see that in the early 90s, the Ninth Finance Commission had sought some legal opinions on specifically this juxtaposition between grants under Article 275 and grants under Article 282. And they received, there was a roundtable conference, and they received a bunch of opinions from renowned jurists that you've all heard of, including Nani Palkiwala, A.G. Nurani, K.K. Venugopal. And the sense that they all reiterated, albeit with slightly different technical arguments, was that Article 282 was not envisaged to be this regular channel. And they all sought in different ways to re-establish the primacy of the Finance Commission as the institution that ought to have the largest say in how much money is being transferred and how it is being transferred between the center and the states. We're talking about the early 90s, so the Planning Commission was very much around that time as well. And you can see the second point that is there in the bullets. This was K.K. Venugopal's argument, who's currently the Attorney General, of course. This was his argument that perhaps when Article 280 says that the Finance Commission can make recommendations regarding grants in aid, we should see that as not just Article 275 grants, but also Article 282 grants. As of now, what happens is that the Finance Commission reports do make some observations about centrally sponsored schemes, but that is not traditionally considered to be part of their mandate. And the center does not really take it as seriously as it does the Finance Commission's recommendations on other parts. But the reason why we point this out is because there were some opinions around this time which tried to make this balance right, because there was a sense that there was an imbalance, a disharmony that was happening over here, which these jurists remarked upon. Which gets us to the major case on this point, which really holds the law of the land as of now as well, which is Bhim Singh versus Union of India, 5-judge bench, Supreme Court 2010, where this was challenged. It was challenged that the proportion of schemes that happen under Article 282, there were arguments that were made that this upsets the federal equilibrium and so on, many of the themes that we have been talking about over the last hour and a half. And interestingly, the Supreme Court concluded in this case that no, actually, this is a wide provision and it's not made expressly subject to any other constitutional provision. And so we cannot interpret it in a restrictive manner. That's what the Supreme Court concluded. But it concluded this while also remarking in its conclusions that 282 is normally meant for, and I quote, special, temporary, or ad hoc schemes. So even in this judgment, on the one hand, the Supreme Court says actually we cannot put any fetter whatsoever, but at the same time also recognizing this same sense, which has been consistent ever since the drafting, as Ritvika pointed out, that this was meant to be not a regular channel. This was meant to be for something unforeseen, for something ad hoc. The Finance Commission, as Nikhil pointed out earlier, is not a permanent body. So it can't envisage every grant. If something happens suddenly, then perhaps you need an Article 282. But that's very different from having scheme after scheme as a regular pathway. And that really kind of destroys that nuance between what different articles were envisaged for. And what's more curious, I think we can go to the last slide now.
Yeah.
So this is what Bhim Singh said, but there are many reasons to perhaps contest this. And these reasons are not just linked to, so far we've only been talking about the federal fiscal relations and Article 282. And even just looking at Article 282, there is reason to believe, as the jurists in the 90s thought, there is reason to believe that there is something not quite right about this outsized role that Article 282 plays. But the reasoning that was there in Bhim Singh actually points to a larger question, which is that in Bhim Singh, they said that our constitution is a quasi-federal constitution, and it's a center-heavy constitution, and therefore we have to give this a very wide interpretation. We cannot possibly have a restrictive interpretation for this provision because it doesn't explicitly say that it is subject to any other article. But it's interesting for the Supreme Court to say this in 2010, because by 2010, there was already decade after decade after decade of jurisprudence where the Supreme Court had precisely done what it said it cannot do in Bhim Singh, in the context of other articles, of course. All the way back to the early 1960s, you had Atyabari Tea Company versus State of Assam, a case which you guys might be familiar with. It was about the freedom of trade provisions, but that was also a case where the Supreme Court was like, we need to be conscious of the fact that we are a federation, and when we interpret constitutional provisions, which is what the Supreme Court does in order to adjudicate disputes, we need to be aware of this overall status, and that awareness has to have a bearing to that interpretation. And this is all the way back in the 60s. You, of course, had Keshav Nanda Bharti in the 70s, wherein federalism was part of the basic structure. You had S.R. Bomai, the famous case on Article 356 in President's Emergencies. This was in 1993. And in this case, it is very unequivocally said that we need to, because of the federal structure of the Constitution, we need to put a certain interpretation to Article 356 that ensures that the federal structure is upheld and not subverted. And this was a 9-judge constitutional bench, and this has been cited repeatedly. Cite a very recent example. In 2018, you had the government of National Capital Territory of Delhi versus Union of India. That was regarding the lieutenant governor's power. There's so many cases in, where time after time the Supreme Court is like, because India is a federation, if there are two possible interpretations of an article, then we should prefer the interpretation that upholds the federal structure and does not really whittle down the powers of the states. And yet Bhim Singh appears to contradict this larger principle, which I certainly think is something that can be contested. And that is indeed our argument that it deserves to be contested. Although, of course, that is the law of the land at the moment. And I'll just end with this thought, and please do ask questions after this, that taking everything together, all of these issues that we've seen with CSSs in practice, and a lot of these issues are also shadow issues, as I said, because they're about counterfactuals. It's hard. It's genuinely hard for me as well to imagine a world where these centrally sponsored schemes do not play the huge role that they do. What would it mean? Many of us, I'm sure, can't even imagine a welfare regime where it's the state schemes which are in the national news. That's what we hear of, because at the moment there has simply been no scope for that. But if we were to look at all of these from these practical perspectives and from this constitutional interpretation perspective, if we were to interpret Article 282 in the manner in which the Supreme Court has interpreted Article 356, for example, or the freedom of trade provisions, what would that mean for CSSs? In spirit, it ought to mean something like you should use that power of making grants in a way that does not undermine the state's autonomy, but rather enables them to exercise it in a more meaningful way. Now, this is at a principle level. What does that look like at the CSS level? And that gets me to the last bullet point that you can see on this slide. This should mean, for example, genuinely using CSSs for only special and temporary purposes. It could also mean reducing CSSs, but not just reducing, but also reimagining them a little differently. You could have conditions that are specific based on which state we are talking about. You could also have CSSs which target not really the performance of particular inputs or processes, that, okay, you need to have so many teachers per school, but rather in terms of outcome, that you need to have so many graduates, for example, and we are okay with some flexibility in terms of how you achieve those targets. They could focus on capacity building, which enables states to ultimately take their own decision rather than forever becoming dependent on this line of agenda setting. And this is what would actually enable the promise of the federal structure to really blossom. This is what, rather than asking the question, how do we tailor make the Sarva Shiksha Abhiyan for Sikkim and for Goa and for Gujarat? Why shouldn't the question be, how can we as the center support Sikkim, Gujarat, Goa, whoever else, to come up with their own solutions? And maybe you could have CSSs where the conditions are regarding monitoring requirements, for example, accountability measures. You do it howsoever you want it to, but what we will measure you on is in terms of targets which are defined in an open-ended sense. So I mean, these are just some examples, and I'll just end with this thought that our focus in this project was not so much about having a lot of prescriptions for CSSs themselves, because you can find a wealth of literature in economics and political science mainly on this specific point. But we wanted to kind of work with the constitutional side of things, and we actually find that it is consistent. A lot of the specific design recommendations for CSSs that are there are something that we agree with, but not just at a practical level, but also at a constitutional interpretation level, consistent with the Supreme Court's own jurisprudence. So I'll end with that thought, and thank you for your patience for listening to us. I know this is a very heavy topic with a lot of information in it. So yeah, happy to take questions on this part and overall as well. Thank you.
Thank you, sir. We'll take any questions if there are. Yes, sir. There's a question from Nikhil. He says that to implement the centrally sponsored schemes, the government plays a pivotal role. However, nowadays we see that the central government is taking a lot of credit for centrally sponsored schemes like Atmanirbhar Bharat, which are implemented by the state government at the end. Is it because of the reach of the central government at the grassroots level enabled by the technology, or is it a new political environment, a more centrally concentrated structure?
Yeah, Nikhil, thanks for that question. It's a great question. And it sounds to me from this question, you might have read some of the recent research on specifically this point. There's a paper by Yamini Iyer and specifically on this point about how this aspect of taking credits, So they say that like 10, 15 years ago or something in the 2000s, while you still had a lot of centrally sponsored schemes, there was a way in which politically states were able to take credit for that. But in the current political environment, as you correctly allude to, there is more of a focus on branding them in a certain way, in naming them like the Pradhan Mantri XYZ Yojana, in the pictures of political leaders that are used in them, and so on, which has kind of reduced the options for the states to take credits for this. Now, again, I don't know if this is right or wrong. This is a matter about political negotiation, and it's a very interesting point about how all of these things kind of come together. So you have something that the Constitution permits, you have something which political parties want to do, and really the skill in this is in how do you manage to, if the structure is a certain way, how do you make that work for you electorally? That's the question, isn't it? And so earlier when you said that state chief ministers were able to take credit for this, that was them being able to politically negotiate that in a manner that even though we don't have a say on the negotiating table, we will have a say on the credit table, and there was some skill in that. But at the moment, that skill appears to have been lost, perhaps because the center and its current dispensation is more smart about it, frankly, and that's how politics works. But yeah, it's a very interesting parallel narrative that's also going on with respect to CSSs.
Yes, sir. I think that's all we have for today. Thank you so much, Ritvika ma'am and Kevin sir, for giving your valuable time. It was a vibrant and intellectually stimulating session, and we do have a better view, and I would say a different view of Article 282 now. And I'm sure we would like to go home and read more about it now. So thank you for that. And I have a small notice for the participants. I'm sending a feedback form in the chat box. Please fill it before you leave the session. Thank you, ma'am. Thank you, sir, for your time.
Thank you. Thank you so
Thank
much
you.
for
Thanks
turning
a
up on
lot.
a Saturday morning. It means a lot. 50 odd people on Saturday morning. I'm thankful.
Yeah,
Thank you so much.
It's amazing. Yeah, thank you. Thanks for having us.
Great.